Hello, everyone. Welcome to another Agenda IDS. I am Patricia Porto, the Academic Coordinator of Dannemann Siemsen Institute. Agenda IDS is an online event in which we address important topics regarding intellectual property, law, and technology. I always invite experts on the subject to share their experience with us. And those who miss the live event will be able to access the record content available later on the Dannemann Siemsen Institute website. And today, we will debate about the key trademarks procedures updates in the Brazilian Patent and Trademark Office. And to discuss these topics, we invite experts on the matter. Today with us, we welcome Elisabeth Siemsen do Amaral, bringing open remarks that provide context to our discussion and presenting our lectors, Philip Dannemann and Rafael Attab. Elisabeth is a partner and member of the board of directors of Dannemann Siemsen, managing partner at Dannemann Siemsen Latin America, and member of the IDS Advisory Board with more than 35 years of experience in IP. She's specialized in trademarks with focus on prosecution, administrative litigation, and strategy. She's a member of the Board of Directors of the International Trademark Association, INTA, a member of the Global Advisory Council for Latin American Caribbean, and of the Leadership Development Committee of INTA. She was president of the Inter-American Intellectual Property Association, ACP, and is currently president of its Ethics Commissions. She's also member of the Board of Directors Council of the Brazilian Intellectual Property Association, ABPI, and member of the Audit and Advisory Board of the São Paulo Intellectual Property Association, ASPI. I would like to thank you very much, our guests and the audience, for being here with us today. And now I give the floor to Elisabeth. Welcome, Elisabeth.
Thank you, Patricia. Good morning, good afternoon, good evening. It's a great pleasure to welcome you all to our roundtable, Trademark Registration in Brazil, BPTO latest updated. I'd like to thank you all for being here, and my special thanks to Dannemann Siemsen Institute, IDS, for this kind invitation. It is a privilege to open today's sessions by highlighting the important steps the Brazilian Patent and Trademark Office, the BPTO, has recently taken in the modernization of its trademark system. This effort reflects the institutional commitment to improving performance in the delivery of its services. Over the past year, the BPTO has put forward a set of reforms designed to improve the way the office interacts with its users. These reforms were not conceived in isolation. They are part of a broader strategy to make the trademark system more agile, transparent, and user-oriented, while aligning Brazilian practice with international standards. Today, we will look at 6 key updates that directly impact trademark owners and applicants. The registration of advertising slogans, registration based on acquiring distinctiveness, priority processing of trademarks, the simplified opposition system, recognition of high renown, and the introduction of artificial intelligence in trademark examinations. Taken together, these 6 measures show that BPTO is moving closer to users, listening to their needs, and embracing innovation as a way to serve society more effectively. These changes create both opportunities and challenges for trademark owners. On one hand, they bring new possibilities for protection, quicker decisions, and more predictable procedures. On the other hand, they also require more strategic planning, especially in relation to evidentiary standards and adapting to new procedures. Actually, this is the moment to transform challenges into opportunities. These changes call for more strategic management of trademark portfolios. And those who anticipate and adapt will gain the most from the changes the BPTO is implementing. And with this perspective in mind, I'm pleased to introduce our speakers, Felipe Dannemann Lundgren and Rafael Atabi, who will guide us across these updates in details. They will help us to understand not only the legal framework, but also the practical implications for business and brand owners. Felipe Dannemann Lundgren is partnered at Dannemann Siemsen and a member of IDS Advisory Board. He has over 20 years of experience in intellectual property and digital law. He is current president of the Industrial Property Committee of the Brazilian Bar Association, Rio de Janeiro chapter, and vice chair of the Unfair Competition team at the Marques Association. He also served as a member of the board of the Brazil-German Chamber of Commerce. Felipe holds a master's degree in intellectual property and competition law from the Munich Intellectual Property Law Center. And Rafael Atabi is also partner at Dannemann Siemsen and a member of the IDS Advisory Board. His practice focuses on the strategic management of intellectual property rights portfolios, with particular dedication to high-profile, complex matters in the field of trademarks. Rafael is a member of the board of AIPPI, International Association for the Protection of Intellectual Property. He holds a master's degree in international law of integration from the State University of Rio de Janeiro. So, Felipe, the floor is yours to start with our first topic, the registration of advertising slogans as trademarks. Please.
Well, thank you, Elisabeth. Good morning, good afternoon, good evening to everyone who is listening to us. I also thank IDS for the invitation. It will be a pleasure here to be trying to share some of the experiences about these new topics. Before I get into the proper topic, I would just like to announce to everybody that whoever has questions, please send them on the chat, because we will be checking the chat while we speak. And if possible, we will try to address all questions and observations on the different topics as we speak. So the idea here is to do something very dynamic. It will be almost like a conversation between Rafael and I. And so please, if you have any questions or any observations, please join us in this conversation as well. So as Elisabeth already introduced, the first new recent update of the Brazilian Trademark Office is the examination of slogans. This is not really a completely recent update anymore, because the new guidelines of the Trademark Office have been in place for over a year now, since end of November of last year. But it's still a very important topic, and it's a very positive development in the Trademark Office's understanding. So we thought it was worth to bring it to your knowledge. So slogans in Brazil, according to the Brazilian IP law, a sign or expression used solely as means of advertising cannot be registered as a trademark. So traditionally, the Brazilian Trademark Office has applied a very strict understanding of that provision of the law, and used to reject, in practical terms, basically any signs that look like a advertising expression or like a slogan. I mean, to be honest, if the sign would have more than 3 words, it would very likely be rejected by the Trademark Office. So it was a very strict understanding. With the new guidelines implemented since the end of last year, the Trademark Office is now adopting a much more flexible understanding and interpretation of the law. So basically, what the new guidelines are stating is that if the slogan can also be perceived as a source identifier, as a trademark, it may now be registered in Brazil. And this is a very good and helpful development for the users of the trademark system in Brazil. So now the BTO will also consider the inherent distinctiveness of the signs, like it already does with usual products and services trademarks. So in the new guidelines, the Trademark Office has now clarified that the sign will only be rejected based on item 7 of Article 124 of the IP law if it meets both of the following, and here I highlight cumulative conditions, and these conditions are that it serves an advertising function and it is incapable of serving a distinctive function. So in practical terms, in other words, this means that if the sign in question contains any element that is capable of providing the sign with distinctiveness, it will be in principle allowed by the Trademark Office. And here in the guidelines, they even cite some very interesting examples of signs that will be registrable and not registrable according to the new guidelines. And I will mention just a few of them to exemplify the new guidelines of the BTO. So the first one is the sign, the best shoe in Brazil for shoes. And this is not registrable because it's commonly used in the advertising industry. It's basically describing a characteristic of that shoe. It's a laudatory expression, so it doesn't change much from the previous practice. Same understanding for another example cited by the BTO here. Here it is cheap every day. So it cannot be registrable because it describes the conditions that the services are offered. But here's where it gets interesting. So the next two examples are examples that had been previously rejected by the BTO based on the prohibition of registration of slogans, but that now are expressly cited in the new guidelines as registrable signs. The first one is Pan-Americano, all for you, for bank services. Pan-Americano is a bank trademark, is a traditional bank in Brazil. And this is a registrable sign according to the new guidelines because the distinctive element Pan-Americano is capable of conferring distinctiveness to the sign. So this is a major change in the understanding of the Brazilian Trademark Office. The next example is I Can't Believe It's Yogurt, the famous frozen yogurt trademark, which had also had been previously registered, but under appeal and after a lot of arguments before the BPTO, that is now clarified as a registrable sign because even though it's an expression that may be interpreted as a laudatory or recommendation of the offered goods, it is an unusual structure that contributes to consumers recognizing it as a sign capable of identifying and distinguishing the product. So basically, it's an inherently distinctive sign. As we can see, Trademark Office has moved from a very restrictive interpretation of the law to a much more flexible one. And of course, this new approach will open, many new opportunities for the users of the trademark system in Brazil to protect other elements of their marketing campaigns, of their strategic advertising means, and other signs that traditionally were not able to be protected in Brazil. So it's in general a very positive new understanding adopted by the Trademark Office, and one that is worth noting and worth advertising for the users of the trademark system in Brazil. So now, before we move to the next topic, I ask if Rafael has anything to complement. Do you have any further comments, additional observations to the topic, Rafael? If not, we just move to the new topic.
Sure. Thank you, Felipe, and good morning, good afternoon, good evening to everyone. Thank you so much, IDS, for this invitation to speak on these latest developments. And Felipe, I totally agree with you, although this might not be one of the most recent changes at BPTO practice, these last few months allowed us to confirm that the office has effectively changed its standards when reviewing marks which are also composed by slogans, and has been quite lenient on the standards as long as it's possible to detect some sort of distinctiveness on the trademark. And another aspect that I think is quite interesting, particularly for those practicing in Europe, is that the BPTO does not intend, at least for now, to review the actual content of the claim itself that is being made in the slogan, whether it's supported by any sort of objective elements or based on advertisement law, consumer law, and particularly whether or not it's when it comes to sustainability, for instance, if it's true or not. And that's a different approach from what we've seen that has been discussed in Europe with the Green Claim Directive. So at least for now, this is not an issue here in Brazil. Let's see how it develops. But it's certainly a new possibility for trademark holders that are developing their own taglines and slogans.
Perfect. Yeah, many things. It's indeed a very positive development, and hopefully it will stay that way. And I think it was something that used to be discussed a lot in the Brazilian IP associations. It was a request from the users for many years, and that has been addressed by the trademark office, and it's very positive, and we're already seeing concrete results deriving from this new guideline. So now moving to the next topic, which will be covered by Rafael. Can you Rafael talk a little bit about the new guidelines on the acquired distinctiveness and what opportunities this brings to trademark owners in Brazil, please?
Sure, Philippe. This is also a very interesting topic, a very interesting development at BPTO practice, because historically, the BPTO has always refrained from reviewing any claim based on acquired distinctiveness or secondary meaning. The office would say in the past that this was not explicitly provided for in our law, so it was not up to them to review. And historically, the office has always been very restrictive when it came to reviewing factual elements. In very narrow instances would the office review them. So if you had a trademark that had been rejected by the BPTO based on descriptiveness, and you wanted to claim secondary meaning or acquired distinctiveness, you actually had to go to court to secure such recognition. And the court, on the other hand, Brazilian courts, on the other hand, have always recognized that Brazilian law in general would accept protection over trademarks when it's possible to prove that even though this element could have been descriptive in its when it was firstly coined, based on continuous use, effective use, and particularly based on the recognition by consumers and by competitors, it has developed its own goodwill, its own distinctive, and is now recognized as a source of origin. The courts, we have court decisions back in the 80s, back in the 90s, recognizing that. And after a lot of pressure, perhaps from companies, IP holders, IP associations, the BPTO finally accepted to review that and changed its proceedings with a new regulation that will come into force next November 28th. So this is still not in force. And as of November 28th, applicants or registrants, depending on the case, will have 12 months to adapt their applications, and that's a key point, whenever they want to claim secondary meaning or acquire distinctiveness. And basically, so two aspects that are very important here. So basically, what do we have to prove? So first, applicant would need to prove that based on substantial and continuous use of the mark. The mark has acquired distinctiveness by the time it was filed, and that's an important aspect because it's quite restrictive. So you have to prove that by the time you filed the trademark, it had already acquired secondary meaning, at least based on current interpretation of the BPTO and what it has been saying that we'll accept. Of course, we still have to see how it develops, but this is an important aspect. And also another thing that we should bear in mind that based on that there's no supplemental register here in Brazil, unlike the US. So you either go for the recognition of acquired distinctiveness, or the mark will be ultimately rejected. And another aspect which is quite difficult for when it comes to a continental country as Brazil is that in principle, the BPTO will require that such recognition is available and is proven at the national level. That could impose particular burden to some marks that are only regional, but unfortunately this has been so far the approach that the BPTO has been indicating that it will follow. According to the regulation right now, we have certain moments where the applicant may, or the registrant may claim that its trademark has acquired distinctiveness. It could be either on filing date or within the next 60 days. Or you can also apply for this special recognition at appeal level. And this is a very interesting part. You can do that as a subsidiary claim, which means that you can first claim that the mark is inherent distinctiveness for whatever reason, and claim that if the office does not consider this to be the case, that the office should review a subsidiary claim on acquired distinctiveness, and at that particular point, the office will open a new time frame for the appellant to submit evidence on such secondary meaning. But this is not only, these are not the only possibilities. You can also present a defense against a third-party opposition or nullity procedure based on secondary claim, secondary meaning or acquired distinctiveness. So if a third party is challenging your trademark application based on descriptiveness, you will be allowed to defend yourself by claiming that it has acquired distinctiveness as long as you're able to prove that status. So the regulation will still come into force, and we are still waiting for additional details from the office on the guidelines. But we do have some previews on what will be the guidelines, particularly for the review of the evidence to be submitted and the type of evidence to be submitted. And the first one, as I've already said, the applicant will have to prove substantial and continuous use in a period of at least 3 years prior to the filing date. So there was a discussion when this was being in public consultation whether it would need to be approved of 5 years or 3 years. Gladly, the office now is required only 3 years, and that's important because with online social media, trademark can become popular and famous and acquire a new level of distinctiveness in a very quick manner. So limiting the time frame for a shorter period, it has been a request from the IP associations, and it has been approved by the office. Another point that is that the office seems to require will be a survey. This historic, we'll be discussing high reputation in another section of our webinar today, but the webinar the BPTO has indicated that a survey is the objective way of evidencing this kind of acquired distinctiveness. And of course, based on our past experience with high reputation, the office will likely make this evidence almost mandatory, which I frankly don't think it's really necessary for all the cases in this particular instance, but we must follow what's going to happen. And the office has also indicated when discussing this during public consultations that it would request detailed history on the volume of sales and investments made on the trademark, which poses a very difficult point on confidentiality, because at the same time that the office has been indicating that detailed information on investments and volume of sales or offering of the trademark would be required, it has continually saying that they cannot guarantee confidentiality of information provided to the office. So we'll need to see what we are going to do with that, and we need to continuously check with the BPTO how to guarantee that this kind of information, which is crucial for companies and strategic for companies, will not, of course, fall in the hands of competitors or third parties or so on. So this is a specific point that calls for some attention, together with the fact that the office might actually request applicants to prove acquire distinctiveness for each and every product in the description. So in past meetings with the office, they have indicated that if you prove secondary meaning, for instance, for peaches, but you claim fruits, you might need to amend your description of goods to cover only those goods that are actually covered by the proof that you have been able to submit. So this is also a development that we need to watch closely. We don't know what's going to happen, but we should act conservatively if we want to succeed in this kind of new claims. And as a final point on evidence, declarations from third parties will be accepted, but the office has already indicated that if there is any relation, commercial relation or direct or indirect commercial relationship with the applicant, these kind of evidence might not be given very high weight. So we need to see what's going to happen in the future. And also, when the applicant is required to evidence some sort of substantial exclusiveness on the marketplace, as the office requires right now, the office indicates that it might take into account third-party applications composed of similar elements to define whether or not this sort of exclusivity in the marketplace is true or not, which in my view poses a particular concern, because if the applicant is able to evidence acquire distinctiveness also based on survey, meaning that the consumer does recognize that trademark as exclusively coming from a particular source, what weight should it give to all the trademark applications or registrations that exist in the registry and might not even be in use? If they were not sufficient to block the development of this particular goodwill, it should not carry a substantive weight in reviewing the claim of secondary meaning. This has also been discussed when we came to high reputation, and the office has not come up at that point either with a clear position on that aspect. So this is another point that we need to watch closely and see how this all develops. But at the end of the day, at least this provides applicants with a very important tool to protect their IP assets, their trademarks, in a much easier manner than when we had to resort to a court action to make your right valid and have it recognized. So, Felipe, back to you. Don't know if you have any additional comments.
Yeah, thank you, Rafael. I think well, you pretty much covered all the main aspects of the topics. What I just would like to highlight, you mentioned it already, but it's very interesting for me, is that how the trademark owners will need to invest time in the preparation for the application of the acquired distinctiveness, because as you mentioned, I think that the trademark office will be quite criterious in the analysis of evidence. And again, Brazil is a continental country, so we might have some challenges in providing all the necessary information. So again, surveys like they already do in high reputation cases, surveys will probably be very, very important. And so I think it will be very key to invest time in the preparation of the evidence before submitting it to the trademark office. But it's, again, a very good development, something that was requested by trademark users in Brazil for many years, and that has now been addressed by the local trademark office. So thank you for the coverage of the topic.
Thank you, Felipe. And now moving forward to the next topic, which is the priority processing of trademarks, which might be of particular interest to trademark applicants in Brazil, given the latest backlog at the office. So, Felipe, what's there with the BPTO on that aspect?
Well, again, a topic that has been asked for many years from trademark practitioners here. We're also a little bit envy because patent practitioners already enjoyed some priority processing at the Patent and Trademark Office. So it was not fair that we would not have some conditions also for prioritizing trademark applications. So this is, again, I'm being repetitive, but again, a very positive development and something that might be very useful in very concrete cases. To provide a general overview of the topic, well, the main objective of this topic is to prioritize the examination of trademark applications in Brazil. It applies both to national applications and registrations and Brazilian designations filed through the Madrid system. So it covers pretty much every trademark being applied for in Brazil. The goal of the trademark office is to examine those prioritized cases in up to 2 months. So as you can see, it's very fast. And I think even in international standards, so 2 months is a very fast processing of the case. The project was already implemented. It started on August 7th of this year. So we are now completing almost 2 months of this pilot project. And later on, I will talk a little bit of the statistics. How to apply for the prioritization of the trademark application is basically filling up a form, and the guidelines of the trademark office basically bring 2 modalities of acceleration of examination. The first one is the priority defined by law, and so this is for elderly people, people with serious diseases, disabled persons, and companies that fall under a government innovation program called Inova Simples. So those are pretty much straightforward cases already defined in the law. Where it gets interesting for trademark users in Brazil is the second modality, which is priorities based on strategic objectives and public policies. So, and for this purpose, the applicant must fall into one of the following categories. I will briefly mention them here to you. The first category is the prior user rights. So it's for those cases where the opponent proceeded against a trademark application in Brazil based on prior use of the mark. as established in paragraph first of Article 129 of the Brazilian IP law, which is an exception of our law, which is usually a registration-based system, but that foresees this exception of the prior user rights. And in practice, how the trademark office will do in those cases is that when the prioritization is requested, it will basically it will look at the evidence of the prior use of the mark in Brazil, and if it sees that the trademark is indeed in use in Brazil, it will examine first the application filed by the prior user in Brazil. It will grant that application in an expedited basis, and based on that granted registration, will then reject the opposed application. So this is, for trademark users in Brazil, this is very, very important development and something that can be used in very practical cases. The second modality is those who depend on the granting of trademark registration for the release of public financial resources. Translating that is basically companies or people applying for government loans that depend on a valid trademark registration. I mean, the project is based on a trademark that needs to be registered at the trademark office. So, this is not so usual, but we've had a few cases before dealing with that aspect. So it's also something that can be used in some conditions. The third modality is if the party is involved in legal proceedings, either at the federal or at the state level, involving that particular trademarks. Here, there's an exception. No writ of mandamus are encompassed by this modality, but this is just a minor exception. And here, it's just important to note that this is a very similar modality as one already applied for patent applications. But here, the interesting thing is that the case needs to be in court already. So only trademarks which are already subject of court action will be able to be prioritized, will be examined in those 2 months. But again, this is another very important modality, because if you have an infringement occurring in the market already, you might be able to expedite the examination by the trademark office, and this might provide a lot of clarity for the resolution of the litigation. The other modality is as those who have a product or service resulting from a patent which was prioritized by the BPTO. So this is interesting too. So if you have a patent that was prioritized by the local trademark office, by the local patent and trademark office, you might request the prioritization as well. So this is something good. Here, there's a limitation of only one trademark per accelerated patent. So if you had one accelerated patent, you'll be able to get one accelerated trademark. There's this limitation, but still, something that can be very useful as well. Another modality is legal entities that are considered scientific, technological, and/or innovation institutions as defined by law. So this is very specific. Also, another modality is individuals that were mentored by the Patent and Trademark Office under technical cooperation agreement. So this again specific. And the last one, those applications that are covered by a situation of public interest or national emergency declared by the federal executive branch. So this is basically for trademarks which involve some sort of public interest around them. So for the priorities based on strategic objectives and public policies, there will be a limitation of 1,200 cases at the beginning. For priorities based on the law, there's no limitations. So if the person proves that it's over 65 years old, it may just get, or that it has a serious disease, it will be, the trademark application will be expedited by the trademark office. Here, important remark is that each applicant will be able to prioritize only up to 3 trademarks based on this pilot project. So we have to be careful not to be starting to claim many prioritizations. We have to really select which are the important cases. And because I think the trademark office is implementing this project on a pilot basis, so it wants to see whether we'll really pick up or not. So this is an important aspect. In terms of official fees, for the priorities defined by law, there are no fees involved. For priorities based on strategic objectives, the fee is of 890 Brazilian reais, which is less than $200. So the fees are probably not going to be a very major aspect here, especially for foreign applicants. A little bit about the statistics, which is interesting. The statistics that are available until now are only of the first month. So the project started on August 7th, and we have the statistics available up to August 31st. Let's say the first 23 weeks of the project, we had 222 cases of prioritizations based on the law. So 84% of them are elderly people. So this was already somehow expected. And 18 cases based on priorities of strategic objectives and public policies. I was a bit surprised with the number. I would expect higher numbers. So 18 cases in the first 3 weeks, it's very few in my view. Again, we don't have the numbers for September, so they might have picked up because August was exactly when the project started. So I think as it picks up, probably numbers will grow. But out of the 18 cases that were prioritized on this modality, 11 of them were for ongoing infringement court actions, which is also somehow expected. 4 cases based on oppositions, which were based on prior user rights, and 3 cases of legal entities that are considered scientific, technological, and innovation institutions. Only 1 case has been examined so far based on prior user rights, so we're still yet to see the decisions of the trademark office. But again, it's very handy, especially for trademark owners which are facing an infringement in Brazil or that are using a trademark in the Brazilian market without the registration, and somebody is trying to register their trademark. This acceleration might be a very interesting tool to fight against infringements. Again, other modalities such as public financing is also important, technological entities, but I think especially these 2 infringement cases and prior user rights, it's something that we should definitely keep in mind when we develop trademark strategies in Brazil. I think that's basically what I wanted to talk about. Rafael, I don't know if you have any further comments on the topic.
I agree, Felipe, that this is a very important tool for trademark applicants in Brazil, particularly when you take into account that backlog is unfortunately increasing. And for context, we have in Brazil each year almost 500,000 trademark applications being filed. So when you're able to prioritize a trademark application and have it decided within perhaps 2 months, this would be certainly very useful. But frankly, I'm not so surprised with the low numbers on this because of the limitations that the office have imposed on the instance where you can prioritize a trademark aside from the regular legal possibilities. And we hope that with that, the BPTO might be convinced that it can open to new situations, such as a cease and desist letter, for instance, instead of waiting for an actual court action being filed, so that the parties could perhaps come up with an agreement before they had to resort to court. So let's see what happens there.
Perfect. Thank you. Well, again, we haven't received any comments or questions yet, so please feel free if you have any questions on one of the topics we covered so far, please send them to us through the chat. So now moving forward to the next topic, which is the new guidelines for the recognition of high reputation trademarks. So Rafael, could you explain the new rules for the recognition of high renowned trademarks and their significance here in Brazil? The floor is yours. Rafael. Is he there? I think he got disconnected. Can you see them, Patricia? No.
No. Maybe I will check. Maybe you can proceed explaining the. I think
Yeah.
Rafael.
I think
Come back.
let me. I just saw that there was a comment here on the chat, so I'll read it maybe while Rafael reconnects. So Andrea Passinhas here is saying that as regards the priority examination of trademarks, it will be very helpful if the trademark office were to allow in the future priority examination to cover extrajudicial measures such as cease and desist letters, as well as situations involving pharmaceutical trademarks whose registration is required by Anvisa, the Brazilian FDA, for the granting of a license. So the good news is that they are very open to considering such a situation. Indeed, Andrea, that's a very good comment. As Rafael already mentioned, it would be ideal if the trademark office would expand the possibility of prioritization to cease and desist letters. And this other aspect you brought for the pharmaceutical trademarks that depend on a registration at Anvisa, that's also certainly an important aspect. So thank you for the observation. And I guess now Rafael is back. Can you hear us, Rafael? Or he's still frozen?
Felipe, I think he's still frozen. I will check with him.
Yeah.
Do you want to proceed to the next topic that you will discuss?
Oh, yeah. Maybe I can jump then to the topic of the pro forma oppositions, and then we can go back to the high renowned trademarks.
Perfect.
So we have time for him to reconnect. If not, I will jump into and I will briefly talk about high renowned trademarks as well. So let's say simplified opposition system that is being introduced by the trademark office, or I prefer to call it pro forma opposition system. It's basically another possibility for trademark users of filing oppositions against applications based on a senior trademark. So based specifically on Article 124, item 19 of the Brazilian IP law. And basically, it's a pre-approved proceeding. The opponents will need to file a form provided by the trademark office. They will be able to cite a maximum of 5 anteriorities, so no more than 5 senior trademarks will be able to base that opposition. The opposition will, as said, will be based exclusively on senior trademark rights. It's not possible to cite any further legal provision other than Article 124, item 19 of the Brazilian IP law, and to insert any text or any sort of arguments in this opposition modality. The main benefit that is aimed by the trademark office is to expedite the examination of oppositions in Brazil. So the goal of the trademark office for this year is to examine those pro forma oppositions in up to 21 months. Currently, the trademark office is taking a little more than 2 years to examine normal oppositions. So this will be an expedited modality for trademark users. I think one of the main reasons that led the trademark office to introduce this new form of opposition was the fact that, according to their statistics, more than 88% of granted oppositions in Brazil are based solely on Article 124, Item 19. So it's by far the most relevant legal basis for trademark oppositions in Brazil. There is an exception, which is if a normal opposition is also filed against that application, then the examination time will follow the ordinary term for a usual opposition. So this is also important. I mean, filing a pro forma opposition will not necessarily guarantee that the examination will take place on an expedited basis, because if a third party also files another ordinary opposition, then the case will follow that time frame. This pro forma opposition was not yet implemented by the Trademark Office. The expectation is that it will become available as of December 20th, 2025. So we still have some time to prepare for that. My personal view of this topic is that it's, of course, another positive innovation brought by the Trademark Office. It will be particularly useful for, those parties that intend to oppose a trademark but are maybe negotiating an agreement or trying to force the other party to limit their list of goods or services. And while they are in those negotiations, they may just file a pro forma opposition, make the Trademark Office aware that they intend to proceed against that trademark. And if the agreement is later reached, they can just withdraw that simplified opposition. On the other hand, as you can see, the modality of this pro forma opposition is very restricted. So no arguments at all, no text at all may be inserted in the opposition form. And so I think this modality will be useful in very, very specific cases where the trademark owner is not really interested in convincing the Trademark Office about the conflict, but it just wants to file an opposition. Also for very blatant cases of entire reproduction, identity of products, this might be an interesting alternative in Brazil. Rafael, I think you're back. Can you hear me?
I'm back, yes. Sorry, I think when I said I was surprised, something happened with my line. So I'm not surprised anymore.
Any comments on the pro forma opposition procedure?
I think you covered it all. I think it's a good opportunity for opposing parties to preserve their rights whenever they are negotiating, or when there's very specific and narrow point to be addressed to the office.
Okay, so now moving forward to the high renown topic, Rafael, can you drive us a little bit through the new guidelines of the Trademark Office and what's new on the procedure for the recognition of high reputation trademarks in Brazil?
Sure, Felipe, thank you. And just to give some broader context here, in Brazil, we have this special protection for very famous trademarks. So once it's registered, you are able to seek a special declaration from the BPTO, which will protect the trademark for whatever classes of goods and services. It's a very, very broad protection for very special trademarks. And because of that, the BPTO has been applying quite stringent standards for reviewing this type of application for high reputation. given the scope of protection afforded to those trademarks. The last guidelines were published around 10 years ago. And what the office noticed is that as it started to require surveys as mandatory proof for the high reputation declaration, they started to notice that there was some sort of difficulty from some of the applicants to understand what the office was expecting with the survey, particularly with regard to questions and to the possibility of indicating that it has reached the level of awareness and the level of reputation, including recognition of quality by the public that the office would expect for this type of trademark. Then what the office decided to do was to establish some guidelines for the survey itself, almost a methodology to be coined to help applicants to be focused on what the office was seeking when they asked for a survey for this type of protection. So after discussing the issue with survey companies, some of them which were continuously used by applicants in their applications for high reputation, and also after discussing that with stakeholders, they came up with some standards and guidelines for this type of survey. And as you probably know, when you apply for the recognition of high reputation, you have to prove a high level of awareness around the country, a high level of exclusivity as well, and a high level of reputation, meaning that the consumer would recognize that the products or services under the trademark as of having a high quality or having a high level of recognition. So what has the office done with that? The office has established some criteria for the questions, some criteria for the scope of the survey, including a minimum a number of interviews of 2,000 around the country, and also certain guidelines for how the research is going to be, the survey is going to be conducted relating to the trademark. If it's a word mark, it should be shown to the public or to those responding to their survey, either in block letters or being asked for the phonetic aspect. If it's a black and white logo, you can use colors. Which was also a doubt when we were preparing the surveys together with the survey companies. And there was this very interesting discussion about the possibility of online surveys. Initially, the office was a little bit conservative regarding the acceptability of this type of survey, particularly for services. They are offered online mostly, but we managed to convince the office that there should be no restrictions toward online surveys, as this is a valid methodology for this type of survey. But at the end of the day, one of the main aspects that raises some concerns that should actually attract our attention here is the minimum level of awareness established by the BPTO regarding the results of the survey. So right now, the office requires at least 61% of both recognition and valid association between the trademark and the goods. That means that if you're not able with your survey to reach the level of 61%, already excluding the margin of error, which is usually of 2% in this kind of survey with 2,000 interviews. So we would actually have to reach 63% of awareness and association, and not only awareness. This is the first bar. This is the threshold to actually be able to apply for this type of recognition. Even then, you will only be easily able to get and to succeed in securing high reputation if you actually achieve 71%. If you achieve that level, the office will be comfortable with granting you that recognition. If you are between 61 and 71, you actually need to build a strong case on the high reputation that your trademark has achieved. So this is a very high threshold in my view, particularly when it comes to a continental country as Brazil. And right now, trademark owners will have to prepare for that, doing test surveys, see if they can really achieve that high level of recognition, or what can be done. For instance, additional investments on publicity, additional investment on marketing, activation of the brand, and other strategies that might be necessary to achieve, particularly when it comes to certain regions or certain social classes where the trademark has not really achieved the necessary level of awareness and correct association. On the other hand, the office knows that this is a very high investment for applicants when it comes to trying to secure this kind of recognition, and they have offered both their online channels and also contacts to try to cooperate with applicants when developing their surveys, whether or not the questions will be accepted, whether or not there should be additional questions, or even if the results will be in the right direction. So it's possible to discuss with the office draft surveys, for instance. They have opened that channel. However, they have also indicated that they are not able to provide full confidentiality to the information being provided, which means that if an applicant provides confidential information on sales, on investments, on advertisement strategies, so on, the office has already said that they will not be able to provide full confidentiality, and that we should reach out to them to discuss how this can be done. Once again, confidentiality becomes a very sensitive issue when it comes to recognition of a special protection afforded by our law. So this is also a point of attention. At the end of the day, at least the new guidelines provide additional certainty on what to do with a survey and how to actually prepare for the high reputation application, avoiding that additional expenses are incurred, as it was in the past when we submitted a survey. The survey was not good enough for the BPTO, and they asked for additional questions or additional points to be proven, which would require basically that a new survey would need to be done. So I think that this is, and for the sake of time, the key aspects and the key takeaways when it comes to this new methodology that has been developed by the office. But Felipe, if you have any insights on that.
Thank you, Rafael. You covered very well. Again, my only remark here is about the fixed percentages. So I don't know what you think about it, but in my view, fixing the percentages beforehand, it's something that really, makes the whole proceeding more stringent, and especially because you have cases which you can be more flexible and maybe cases where you need to be stricter. So my only remark is about the fixed rates established by the trademark office. And I believe you agree, we discussed that before, and I believe you also agree with that. Uh, we have a question from the audience here, Rafael. Victor Kronenberger is asking, uh, as for the survey related to highly renowned marks, my understanding is that the BPTO establishes that when survey results range from 61 to 71%, further supporting documentation must be provided. Do you agree with that interpretation? And what type of additional supporting documentation do you believe the BPTO expects in such cases? What's
So,
your view on that?
That's a good question, and I think, as you put it, Felipe, the matter of percentages we need to be reviewed, particularly by our courts. We do have precedents in a very interesting case back in the when we had the notorious trademark, which preceded the high reputation one, but had similar standards and requirements. And it's at the time the BPTO was requiring 70% of awareness, and it was a trademark for cereals, and it achieved 53%, if I'm not mistaken, which is huge when you consider that we have 200 million people in Brazil. So he's saying and the court bluntly said that requiring over 70% is requiring almost absolute knowledge of the trademark, which is almost impossible to reach. And they added that the law was not made for a handful of trademarks. So they accepted 53% in that particular case. And that was the case also for the BPTO prior to that new standards. If you had up more than 50%, you could, with other types of evidence, reach and succeed in obtaining high reputation. And as Victor asked, and you're absolutely right, if based on current new guidelines, if you have not achieved 71%, but has been able to achieve over 61%, between in that specific range, you need to submit additional evidence, which can be, for instance, information on the history of use of the trademark in Brazil, the investments on publicity, an assessment on the value of the trademark, and whatever evidence you might be able to submit, showing that indeed that trademark has achieved a very high degree of reputation in the country, and that use by a third party would necessarily end up representing unfair advantage and free riding on such reputation. So once again, I think that we need to see what our courts will say about that very high standard on 61% or even 71%. But regarding this additional evidence, I think whatever you can submit showing that it has a very high level of awareness and investments have been done and that consumers have been recognizing, for instance, with prizes and awards that the trademark may have achieved, it would be probably sufficient to be able to achieve. Other than that, I think that new very high standards for the high reputation might unfortunately affect particularly luxury and fashion trademarks, which sometimes are victims of unfair competition and free riding, but sometimes are not able to achieve that high level of recognition among the entire Brazil and among all classes, all social classes. And that could end up needing additional strategies when you need to defend a famous trademark that might not be at the level that the office requires for the recognition of high reputation trademarks.
Thank you, Rafael. Very clear. Now moving to our last point, I think a brief point. Also, Rafael, can you just share with us the initiatives of the Trademark Office as regards artificial intelligence? Of course, that's a topic that always, generates a lot of attention. So tell us what is the Trademark Office working at this moment?
Sure, Felipe. The BPTO has shared with us and without the IP community that it's also looking into AI. I think everybody is looking into AI. So if you don't look into AI, probably you're not in the century. But there are no concrete outcomes so far. But they have shared with IP practitioners some of their goals and some of the current projects. And the first one is to develop a search tool for examiners, which is supposedly will be available for the examiners by the end of this year. We have not heard whether or not this is indeed a concrete outcome or an output of the endeavor, but that's their aim. And they would also like to, at the second stage, provide users with the same level of tools to make their filings easier and also have a better predictability on what the outcome would be when it comes to trademarks. Of course, we are now talking about trademarks. There are also some other developments being made at patent level and the patent department, but related to trademarks, these are the key expectations. We know that they have been trying to partner up with some other IP offices, have been talking to WIPO as they've always done, have been talking to EU IPO, but at the end of the day, the main expectation from the office is that artificial intelligence tools become an additional asset, an aid to the examiners and to the users, and will not simply replace examination or create a completely autonomous examination. Examiners in Brazil are very confident about their work. They have very high quality, and so they want to preserve that. But of course, as we said before, the BPTO has been receiving over almost 500,000 trademark applications each year. So they have to think on how to address that issue and how to handle that volume. And AI has been a possible avenue for them as a tool for helping them out based on the investment constraints that they always face relating to the hiring of new examiners. So let's see what happens. At least we know that they are looking into the matter with concrete objectives.
Yeah, thank you, Rafael. I have nothing to add. It's basically it's still very uncertain in what direction the trademark office will go. The certainty is that they need to look at AI, as all offices around the world are doing, to aid on their job, which is becoming more and more challenging with the amount of trademark applications that we receive each year. I was reading a statistic the other day that Brazil is on the path of becoming, I think, the fourth biggest trademark office in the world. So it's huge challenge for this examination, and certainly AI can have a very important role on that. I think we can open for questions. I see there's one question from the audience. I will read it here. she's asking here, Rafael and Felipe, regarding the priority processing, in addition to extrajudicial notifications, what other scenarios do you consider positive to include as a strategic priority? Here, I think Andrea already brought a point before, which was very important, the pharmaceutical trademarks, which are also dependent on the registration at Anvisa. So this could also be an important aspect to be addressed. Rafael, do you have any other aspects in mind that come to your mind for the strategic prioritizing?
I think, yeah, I think when you leave it a little bit more open for the argument, because sometimes there's some peculiar cases, and it's you have to build a good case before the office. I think that's the main point. Tagging up with a patent applications is a good aspect, of course, but sometimes a trademark is even broader than that. So I think if the office left it a little bit more open to the applicant to propose why they consider this to be a strategic case, that would be the best scenario. But if we start at least with the disputes and the cease and desist letters, I think it will already be very helpful for achieving better certainty considering the current backlog.
Well, thank you. So as we do not have any further questions or observations here in the chat, so we're coming towards the end of the webinar. Thank you, everybody. I will pass the word to Patricia to close, but I would like to thank for this opportunity. As you can see, we have many opportunities in Brazil, many new developments, so we can think about trademark protection. We have many new tools now available, and we are, of course, always at your disposal to discuss any further possibilities here in Brazil. Patricia, I think your mic is closed.
Thank you. Thank you, Felipe and Rafael and Elisabeth, for all the knowledge you share, you all share with us today. And I would like to thank you, the audience, for the participations and the amazing questions. And I would like to suggest our audience to follow the Dannemann Siemsen Institute in our social media and website for the latest news and content. For example, next month, Agenda IDS will talk about franchising, and each month it's a new topic, and we are each week publishing new informations and articles and in our sites and social medias. So stay tuned and follow us. And I would like to wrap up this. Thank you very much. See you next.